ASC, welcome for this interview.
Good afternoon.
Okay. Good afternoon, Commissioner.
Yes, I'm Isaac Ruto, also Vice Chair.
Thank you. Thank you, Vice Chair.
Good afternoon, Council. Jacqueline Ngutia, Commissioner. You're welcome, and I wish you the very best.
Thank you. Thank you, Commissioner.
Good afternoon, Wakili. Nzilani Caroline, you're welcome.
Thank you, Commissioner.
Good afternoon, Charity Kisotwa, Commissioner. Welcome.
Thank you, Commissioner. Thank you, Commissioner.
Good afternoon, Joaquin Dungo.
Thank you, Commissioner.
Assalamu alaikum, Salma.
Waalaikum salam.
Fatuma Sichale, karibu sana.
Thank you.
Good afternoon, I'm Oluwande Evali. You are welcome.
Thank you.
Good afternoon, Dorcas Odwar, Senior Counsel and Attorney General.
Thank you. Thank you, AG.
Winfrida Mokaya, Secretary, you're welcome.
Thank you.
Very well, thank you, Commissioners, for that introduction. Ms. Ramadhan, if you could start by telling us your county and your ethnicity.
My county is Mombasa. My ethnicity is Nubi. Nubi. N-U-B-I.
Like the ones from Kibera?
Yes.
Okay, very well. We will start the interview. We like to make it conversational so that you can relax. We are not threatening at all. We just want to get the best out of you, so just be comfortable, make yourself comfortable. I think I have to take off the aircon. Yes. If you could start by telling us, Ms. Ramadhan, what makes you distinguished? What distinguishes you from about 100 candidates that we are interviewing so that this commission can recommend you for the appointment of the office of a judge? We want to know, what have you achieved? What are your special skills, experiences, innovations? When we engaged with stakeholders, and you have been watching these proceedings, the stakeholders told us to recommend people who are heavy lifters, those who can work hard and they do not become a baggage to the High Court, which is struggling with a huge backlog of cases. Men and women of high integrity and moral probity who understand the high responsibility of the office of a judge. So within 5 minutes, if you can tell us how you fit in that bill.
Thank you, Honorable CJ, for the question. How I understand, let me start with my experience. Having worked with the Honorable retired CJ Maraga for the entire tenure of his CJ-ship, I will say that I know and understand what it means to be a judge and how a judge works look like. I understand that to be a judge, you must have high legal competency, which is core in your day-to-day activity as a judge. I will speak to this in terms of my my legal training, my work experience, as well as the skills that I've acquired over time that will be helpful and instrumental should I become a judge. My lady, the Honorable CJ, I'll start with my educational background. I hold a Bachelor of Law degree. I also hold a Master's of Law degree from the University of Nairobi. During my master's degree, I did a thesis. I wrote a thesis on the land value taxation laws and their impact on the ownership of property and the ownership and the Article 43 provision, as well as the principles on, under Article 201 and the principles on land policy under Article 60. I am glad and happy to report today that my thesis was actually very instrumental towards the coming up with the National the National Rating Act 2024 that was assented to by the President last year. If you look at that act and with my thesis, you'll actually see it mirrors my thesis. The text of my thesis, the recommendation as well as the conclusion, it is mirrored in that text. With that, counties are now called upon to enact their own legislation on rating and valuation to ensure that, and also having in mind the fact that they shouldn't, as much as they pursue their collection of taxes in terms of rates, they don't deprive Kenyans of their right to property, the Article 43 rights, as well as the rights, the principles under Article 201 on taxation. My lady, I'm also happy to report that that thesis again formed the basis of argument by the Mombasa Law Society of Kenya in the argument in the matter that they filed before the High Court, so where we saw the Finance Act, the Mombasa County Finance Act 2019 being found unconstitutional. And the valuation roll that was rolled that particular time, again being stood down for having not stood the test of the article that I've just quoted. Coming back to my work experience, my lady, as I've already stated, I was the law clerk to the Honorable Retired CJ for the entire tenureship of her CJship. And I'll be happy to say that my work there was to help or to support the Honorable CJ in making decision in terms of research, legal research. I'm happy to say that with my support, I was able to help to support the CJ together with the other judges of the Supreme Court in developing, in making decision in terms of human rights, constitutional law, comparative. Yes, comparative law, as well as the application of the other laws of Kenya. My lady, and again, you will find that most of the decisions made then that I support in their making are of jurisprudential impact, not only in this country, but also beyond the country. My lady, again, whilst at the office of the CJ, I also learned the interaction with various laws of Kenya, not only what is here, but also comparatively. I also learned the organizational structures of the organization of the judiciary, as well as how the judiciary account to the public in terms of the state of the annual address that you give the office of the CJ gives every year, accounting to how the judiciary has performed, as well as writing of media summaries that explains in the language that
other ones you understand the judiciary.
Yes.
And
now coming back to where I work right now at the Office of the Data Protection Commissioner, where I'm now just before that, I will say that actually the judiciary formed my grounding to what I am right now. It shaped me, and I'll actually be happy to be back. Now, going back to where I am right now, I am the Assistant Data Commissioner and also the in charge of, I'm the head of the Coast Region on matters of data protection. There, I will say that what I acquired from the Supreme Court, including the skills and the knowledge, actually made me instrumental in advisory writing. Just for lack of a better word, I'm named actually as the guru in terms of advisory, and all the hard ones, even from HQ, will be allocated to me, and I'll be happy to write them. I enjoy writing, I enjoy working, the Honorable CJ. Also, if you look at my JD from my CV, my work is a lot in terms of what I do just within the region. I cover all the 6 counties. I also cover all the works from the HQ. Under the Data Protection Act, the office has a quasi-judicial function where we not only just deal with the advisories and reviews in terms of impact assessment and the data breaches. We also do sit on matters, and we issue what we call enforcement notices as well as opinions. And with that, again, I can say I'm actually a heavy lifter, being able to carry the workload from within my region and also and beyond.
Very well. Just before we enter the other areas, I see in your other forms you say that you were born in Kisumu. And did you change from Kisumu to Mombasa?
My parents work in Kisumu. I was born where they work, but they come from Mombasa.
Okay,
but
very
yes,
well.
yes, but
I wanted that clarification. Commissioner Mwanza, take us to the next question.
Thank you, Chief Justice. I just want to question you on one or two things. If you, in your sample writing, the case that you filed, civil appeal number 121 of 2023, if you look at the way you started, you start your submission, and then you just delve straight, you start quoting case law, and then you don't seem to analyze. I don't know why. You don't seem to analyze the facts and connect them to the cases. And then at the end, you conclude, for instance, where you say award of damages, you say, prior to of the memorandum of appeal alludes that the applicant has not particularized or proved damages, then you cite a case, and then you ask that the case is dismissed. Why is it that you do not go into detail in terms of, okay, you cite a lot of cases, but you don't seem to link it?
Yeah. So there's no nexus between what I've quoted in terms of case laws and the facts.
Yes. There is actually no fact. You actually quote the cases and then you make a conclusion.
No, and there must be a mistake then. I don't know, because of course you can't just start submission midway. It has to flow from some facts, okay, then or from the facts all the way, because I think it was a running down matter. But
no. This one was yes, it was on a consent. You are appealing against, I think, you are acting for the respondent, and it was with respect to a consent.
Because I don't know what I remember is the one. There's one which was a running down matter, and we had consented on submission of various documents. So it was not it is not in dispute, and I think maybe that's where I went directly to what was in dispute.
Okay. Because
we had consent with the other side.
Okay.
On quite a number of issues. I think the only matter that was left pending was on damages, because even on liability we had already consented.
Okay.
So everything was on court record. The only thing that was left was now on damages.
Okay. And then in your declaration of income and assets, the one that's done to the JSC, you on description and approximate and income, you just say income from law firm depends on business. You don't state the income. I don't know why that's the case.
Yes, it's law firm is also a business like any other, so you can never tell what will be your profit by the end of the year. It's a game of chance. It's not, you can never predict that this is the match that I'll get, and also I'll at that particular point in time, I was only getting what I could in terms of now my partnership bit of it, because I relinquished the firm after I'm no longer in management, having joined the Data Protection Commissioner's office.
Okay, no problem. So I want to ask you one question. With respect to a judgment that has been obtained by fraud, if a matter goes through a court and it is heard, witnesses are heard both in, it's a civil dispute. Okay. You okay?
Yeah, I'm okay.
All right. You can have a bottle of water.
I'm fasting.
Oh, okay. All right. So you get so there is a scenario. There are two parties that are into a dispute in a civil matter. The matter is heard and determined, and there is judgment. And thereafter, one party discovers that there was fraud or deception that was practiced to procure that judgment. How would this party go about setting aside that judgment?
Well, the party to the matter found out that there was fraud.
That the judgment was procured. The defendant, so there is a victor who is the plaintiff. The defendant discovers that there was fraud that was committed to procure that judgment or deception. How would that, and remember the matter has been heard and determined. How would you go about setting aside that?
I fail to connect how there'll be fraud or deception being judges' independence in terms of decision making. So,
for instance, if there was perjury, and it somebody said that these facts existed, and yet they didn't, and it is discovered after the judgment, and then now the defendant, having discovered that, wants to have that judgment set aside. How do they go about it?
So it is part of the proceedings.
Yes.
Later on they discover that
yes.
Yeah, that
yes.
There's something material that was not brought to the court's attention.
Yes, not material. There was actually deception that was used to procure that judgment. You understand the question?
So it was deliberately hidden.
Yes. Yes.
So because once a court makes its judgment, then it becomes functus. So unless there are only now two avenues available. You either you apply for a review of the judgment, but now the review is only depending. There are grounds for review. Maybe they are new.
Yes, it does not fall under grounds for review. Actually, the issue here is there are long-established principles of public policy. One is that that fraud unravels everything, and the second one is that there should be finality in litigation. So when these two principles are competing, how does the court resolve that?
Which principle? The one for finality and the ones for
there's one principle
giving justice to the parties.
Yes, there's a principle that fraud unravels everything, yes. And then there's a principle that we must have finality to litigation. And yet these are two competing public policy principles, and now they are apparent in this case, whereby a deception has been committed to procure a judgment. How would you go about that?
I think then that form a very valid ground for appeal, so that decision is set aside.
But then that issue of deception cannot be used in appeal because it was not initially there in the trial court.
Yes, because there's also an issue of the trial can't now begin afresh.
Okay.
Because the other issue, if it doesn't fall under the ground for review, and again on appeal you are bound by your pleadings, so this is and how come the deception was never? How material is that deception? How material is it to the? How will it shift the balance?
Yes, it was material. It's material. That is why this party wants that case reopened.
And yet both of them couldn't discover it earlier.
Yes. So how would you go about it as a judge? And what would be the proper procedure to to reopen this case? Or in your view, can this case be reopened?
Yes, if at all it's fraud, because I don't know, maybe it's reading deep into the act so that to ensure you give party justice. So unless maybe we put it like under those grounds where under Article the 35 arbitration, where now in case of fraud.
No, it's not an arbitration. It's a judgment actually. It's a civil trial.
So that now in the event of fraud, you can because if at all justice has not been delivered to these people, then and that matter still cannot be. Most likely, even the High Court will just take it back for on appeal. It will just take it back for fresh trial.
So how will that be done?
How
would this party who was suffered an injustice, how would they get a remedy?
For me, the only way to get a remedy, that judgment first of all has to be set aside to ensure that you're not res judicata, you're not sitting on the matter that has been concluded between the same party. Then now, so it has to still go and now be set aside so that.
How do you set
it
aside?
The appeal, it has to be set aside on appeal, that judgment.
Okay, thank you. Yes. All right.
Okay.
Thank you, Honorable Chief Justice. Salma, one simple question from me. There is a plaint. Assume you're now a High Court judge and you're handling a matter. You look at the plaint, and this plaint has two main components. This plaintiff is a company, and the issue at hand is about directorship and shareholding of the company. The other facet of it is that it is a dispute involving ownership of land. Now, in view of Article 165(3), that gives unlimited original jurisdiction to the High Court, and Article 162(2), that provides for specialized courts, and as I've said, you're a High Court judge. Tell us what you would do with such a matter if you were to faced with a situation like that.
Sorry, Commissioner, maybe just, I think I lost you a bit.
Yes, okay. So it's a plaint there's a plaint that has been filed. And there are two facets to this plaint. There is a question of shares, shareholding, and directorship of a company. And then there is also a dispute as to ownership of a shamba. And of course, given the fact that as a High Court judge, you will have unlimited original jurisdiction, and also bearing in mind the fact that we have specialized courts in the Constitution, how do you think you'll handle such a matter if it came before you?
Thank you, Commissioner, for the question. I believe, my understanding is that this is a question of cross-jurisdiction. One, there's a matter on land, and the other one it's a matter that falls under the jurisdiction of the High Court under 165(3). So for me, then, and guided by the Karisa Chengo's case, I will go by the dominant question here. So which one of these will be the dominant question? Will it be the issue of the shareholder? And
there isn't any that is dominant.
So they are equal.
They are equal.
But even if they are equal, the people bringing this matter are directors and shareholders. Or I didn't get
It's a company. It's a company.
It's the company that's suing.
Yes.
In terms of maybe the orders. What orders are they seeking?
The issues at stake are directorship and shareholding in the company. Number two, the ownership of the company.
The ownership of the company and directorship. Yes, then that one.
The ownership of the land.
The ownership of the land and the shareholding.
Yes, and the land is owned by the company.
So I think I'll be guided by the relief that they are seeking before the court. If, for example, let's say maybe they are seeking 4 or 5 reliefs and 3 of them are false, they are not on land use, then I'll assume jurisdiction. But in the event a majority of what they are seeking is...
there are 2 reliefs. One is substantive, and then the second one is any other relief that this court deems fit to grant.
So one of the relief is that the
court to determine the shareholding of the company and the ownership of the land.
So it's a 50-50.
It's a 50-50.
Yes. So being a 50-50, I think I'll still go back to the structure of the pleadings, and see what is the core factor, whether whatever it's pending or is due revolves around the company and the memorandum of and the article of association. Then I'll assume jurisdiction.
Can you dismember it, divide it into 2?
I think that one. I think it's confusing to the litigants to tell them now.
No, you are the judge. You're the judge.
Yeah, but you can't tell the litigant that I'll hear order 1, then this other prayer go to.
So tell us the way out.
Yes, that's why I'm saying I'll look into the plaint, and if from the plaint I see most of the argument, the dispute is emanating from the articles and the memo of association, then I'll assume jurisdiction.
Anyway, fair enough. Thank you.
Good afternoon.
Good afternoon.
Let's go to another subject. What is a waqf? Is it waqf or waqf?
A waqf.
Yeah, what is it?
A waqf is a trust. It's in English, waqf is Arabic for a trust.
Yes.
So what it means is a provision where I live. It's a written trust by a Muslim. You have to have professed the Islamic faith, and now saying that upon my death, if you want, for Muslims, we believe that once you are dead, there are some things that survives you. And one of them is that in the event you leave a property that continue to benefit society, the vulnerable people of the society, and so you can donate some of your property to a waqf. So you say this one is a trust. I'm putting it in terms for myself and my children or whatever you want to name in the waqf, and then now you can either decide to run the waqf by yourself, so that you make it run in the family, so that in the event you die, then someone else you already name from the trust who will take it up after you to administer the trust, the waqf.
Is it inalienable?
There are also two types. There's now, the first type is the one that now will run in the family, and the other one now will be donated to the Waqf Commission of Kenya. Now who will.
That's where I was going to. But
yes.
First of all, is it inalienable? Can you revoke it? Is it revocable?
Now, it depends. There are conflicting findings on this. So mostly what we look into in terms of revoking, and this one, the jurisprudence has emerged mostly from the Islamic states, not within.
Okay, now tell me, what is the legal framework that manages? Is it waqf or waqf in Kenya?
Sorry?
The legal framework for managing waqf.
Yes.
Do we have a legal framework?
Yes, we have.
Which one?
We have the Act.
The what?
The Act. It's called, I can't remember the full name, but we have the Waqf.
We have the Act.
Yes, we have
now,
the Act.
Under that Act, what is the role of the Attorney General and what is the role of the High Court in administering that Act?
The role of the Attorney General is the principal advisor in terms of...
no, within the Waqf Act, Commission Act.
Okay.
Has the Attorney General any role to play?
I believe so, since the Attorney General is the principal advisor, and this a person donated their own work to the Work Commission, that means they've donated it to be administered by the state. So the state now comes in terms of the Work Commission, and the Attorney General must be in as the legal.
What about the High Court?
The High Court, of course, in terms of dispute, because most of these properties that are donated to work, some run to billions. So you will find that magistrate court will not have jurisdiction. So the High Court will definitely be the one to come in. Even Qadis, most of the time, they don't have the jurisdiction. So most of the property, in terms, maybe when there's a dispute, and of course also at times when there's conflict in terms of the emerging Islamic jurisprudence and now how the Waqf is administered here, some of the members of the Waqf still come in and demand some.
What would you say if I told you that Section 29 provides that any matter or dispute relating to the Waqf shall in the first instance be referred to the Qadi's court? So I want to ask you whether the High Court has jurisdiction.
Now, in the first, for what purposes will they be going to the Qadi's court? It depends. Maybe now, what is it that you are seeking? Is it the dissolution of the Waqf? Is it...
okay, so does the High Court have jurisdiction?
Yes.
It has jurisdiction?
Yes, it has.
Now, if you are a High Court judge, under what circumstances will you decide that? Would you revoke the Waqf?
So first of all, it will have come on appeal from the decision of the Qadi.
Yes.
Yes. And revocation of Waqf, it's a bit tricky, Commissioner and AG.
Just one instance in which it could be revoked.
One instance is maybe where the heirs to the owner of the Waqf are left destitute.
Yeah.
Yes.
Thank you.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon, Commissioner.
You okay?
Yes, thank you.
Okay, good to hear that. In addition to what Commissioner Omwanza asked with regards to sample writing, I will ask you some few questions. Why do we ask candidates to submit sample writings?
To know their legal reasoning, their communication skills, how they communicate in terms of what they write and marrying it to the law and the Constitution.
Okay. So you attached 3 letters from your office and their general correspondence where people wrote to you asking for something, their inquiries, and then you responded to them on varied issues. Do you think we are able to understand your legal reasoning, understanding and appreciation of the law, your ability to make reference to case law based on the 3 sample writings?
Thank you, Commissioner, for the question. Yes, one of the jurisdiction of the Office of the Data Protection Commissioner is that we issue advisories to members of the public in matters of privacy. So any entity, it can either be an individual or an entity that feels there's part of the act that they are not so conversant. You remember also, this is it's a new act. So many entities.
So I just want you to tell us whether you think those 3 letters you sent, and for me, I consider them more as a response to inquiry as opposed to an advisory.
So
do you think we are able to understand your legal reasoning, jurisprudential range, adjudicative skills based on those 3 letters?
Yes, Commissioner, because I will say that one of our of the jurisdiction is advisory. We issue advisory opinions, and those advisories actually count in terms of when a matter is brought, a claim is brought against you. In the event you issue an advisory and you are told the parameters of what to do, what is acceptable within the law, within the bounds of the law, and you go over and above it, then that one will determine the data commissioner's discretion on
the 3
how
letters.
much they
Sorry,
will,
Council.
yes. So
I just want you to just confine yourself to the 3 letters. Did you create time to go through the 3 letters?
Yes,
These are letters a member of a public has written to the data commissioner asking for specific information, and you respond to them and tell them A, B, C, and D without necessarily going to the law and analyzing what the courts have decided or what the data commissioner has decided. Because as you rightly say, we want to understand your adjudicative skills, analytical skills, jurisprudential range. For example, are we able to tell your jurisprudential range from those 3 sample writings?
Yes, Commissioner, thank you for so maybe going back to the question, you will find that, like, for example, one of the letters, the question was a member of the public was seeking advisory on whether the right to access under the Data Protection Act should be limited or it should go over and above as provided for in the Constitution. So when in my writings, you could see when now we respond in terms of advisory, we are responding the right to access from the Constitution vis-a-vis the rights of the data subject that is provided for in the Act, and to what extent now can you expand it to mean that in the event you do this, then this will amount to a violation within the meaning of both the Act and the Constitution. So yes, it informs, it already tells you how do I go to apply and interpret both the law, the Data Protection Act, as read together with the Constitution to advise the member of the public, yes, to what the parameters they can go to ensure the right of access is realized.
But you agree with me, they don't make any reference to case law or even the Constitution, as you say?
There is. I've made reference to Constitution and the Act, but case laws, no, we don't.
Okay.
The case laws,
and then,
yes.
If you'd kindly just take time to listen, it will make our work a bit easier. The 3 letters are also unsigned, and they bear no author's name, so we can't even attribute them to you.
Yeah, thank you, Commissioner, for the question. The state officer in our office is the data commissioner. She's the only one authorized to sign letters that come out from the office. So what was required of me was to put in writing that was done by me and in the raw form of it. So that one, the way it is, it's what was done by me. As,
but you agree with me,
yes,
without the name, without your name and the signature, we can't attribute them to you?
Because my name can never appear based on the fact that it is the data commissioner who is the one to sign. But however, they were writings done by me in my own capacity, and after that, now it's when the data commissioner signs that they go out of the office. And they're also public documents, because if you go to our website, you will be able to access our advisories a public document, because it is meant for the public to know what is this office about, to what extent can they exercise this right, to what extent are the parameters to which the right to privacy applies in Kenya. So with that, you'll be able to...
So these, as you say, they are public documents.
Yes.
So you have every person who writes to you, you upload their letters, your responses, if I get it right?
Especially those ones that are very core, that speaks to an element that maybe it's a question that is sought every time.
So do you also
by members of the public?
Do you also list the name, the identity, their postal address, email address, and post on the website?
And yes, unless maybe the particular entity or the individual request that they want to be anonymous. So when now you're bringing in, you ask, do you wish to be for anonymity or yes?
Okay, thank you and all the best.
Okay, thank you. So imagine you're already a judge of the High Court and you get a petition before you. The petition has been brought by a governor who has been charged with the offense of corruption, and he says to you that when he was charged before the trial court set bail and bond terms, saying that he cannot access his office until the criminal matter has been heard and determined. So he's come and tell you that his constitutional rights have been infringed because he's an elected official. he needs to go to his office to serve the people, and the court order has the effect of suspending from office, which is contrary to the provisions in the Constitution that remove a governor from office. The AG, on the other hand, is urging that the bail terms are reasonable and credible in light of public interest. What will you as a judge find in terms of the constitutional questions before you?
Sorry, Commissioner. My lady, I think I missed out on the narrative at some point. So it's been charged.
So you have a governor who's been charged for corruption in a magistrate's court, for example. But he has now come to you and saying these charges before the trial court. When he was charged before the trial court set bail terms, and the bail terms were he cannot go near his office. So he has come to you as a judge, and he's saying, look, this trial court, the bail terms are violating my rights to serve my people, and also the bail terms are like a constructive removal, because I cannot go to work in my office, so it's like I've been removed, when the process of removing a governor is a different process. Then on the other side, you have the AG who is saying, no, don't agree with him, because we need to preserve the integrity of the process in the trial court. So what's your decision on the constitutional questions which have been raised before you?
Thank you, Commissioner, for that question. So the matter that's before me, it's a revision of the bail terms that were granted by the...
No, it's not a revision of the bail terms. He's citing constitutional violation, and he wants you to quash the orders of the trial court based on constitutional violation. It's not a review, per se.
So the constitutional violation is that he was given, some of the term given is that he shouldn't access the office.
Yes.
So, okay. That's the only ground.
That's one of the terms. Maybe he was told to deposit some money, but the one that he's bothered about is that the court has said he cannot go to his office until the whole prosecution is finished and the matter is heard. And he's saying, I'm an elected official. I have to be able to go to my office. And this court, this order of the court, it is effectively removing me from my position as governor. And yet, there is a removal process for governor. So how can the court remove me from office?
So the constitutional question, first of all, being granted, having that he wouldn't access his office as part of the bail term does not mean he's been removed from office, because removal from office is very categorical. It's provided for in the Constitution, and even it's not even a court process at all. Yes, it's a process that's in the purview of other by the yes.
What if he says that he says, I need you to stop my prosecution? Tell the DPP that they cannot proceed with my prosecution. What would you consider, and what would you say?
To stop his prosecution based on maybe the what grounds? That the court, because according to him, he still thinks
he can
this
say
is impeachment.
That this charge that the DPP is bringing is about something that happened 10 years ago. It's taken too much time. It's unfair.
No, of course, if it's a criminal matter, then of course the court is right in assuming jurisdiction in criminal trials. So the matter is right before the court.
There's no exception to that which the court can say, we stop the prosecution. Is there, or there's none?
They stop the prosecution on what? On the ground?
That there's been delay and it's not fair.
No, because I believe the DPP has also been given chance, and they've stated their reason. Maybe they were also collecting evidence. They were doing it. So,
okay. Can you recall any cases whatsoever, or any case you may be familiar with that have dealt with those two questions? The issue of whether bail and bond, the terms are unconstitutional, or whether the High Court can stop the DPP from prosecutions. Are you familiar with any cases? They don't come to
the
mind.
High Court can stop
the prosecution by the DPP. The grounds upon which a High Court can stop the DPP from proceeding with prosecution. What about the bail and bond not being constructive removal of office?
Yes, of course, bail and bond is not constructive removal at all.
Can you recall any case in which a court made the determination on that?
No, it's not coming.
It's not coming. Okay, thank you. Thank you, Madam.
Thank you, Chair. Earlier, when you were addressing the Honorable AG, I think she had asked you about the jurisdiction of the High Court to deal with matters of work, and you said it depends on the value, and that maybe even a Kadhi's court or a magistrate's court will not have jurisdiction. I just wanted to follow up on that. What is the peculiar jurisdiction of the Kadhi's court? Maybe the Chief Kadhi.
The Chief Kadhi, it's in the Magistrates Act. I think it was put up to, is it 5 million or 15 million?
Does the Magistrates Court Act cover the Kadhi's courts?
Yes.
Are you sure about that?
In terms of, oh, sorry. Thank you. Thank you for that. Yes, thank you for that. Yes, under the Constitution, the Kadhi's court jurisdiction is not determined by monetary value. It's determined by the fact that the people before it profess the Islamic faith. Yes, and the matter, yes. So, sorry, I correct myself on that one.
Oh, okay. Now, the question now I wanted to ask you, in a matter for succession, could you please run us through not the steps, but the documents that you are required to file intestate succession?
In an intestate succession, you will file the petition. The petition has to be supported by an affidavit of the administrator. You will also file the affidavit by the sureties.
When you say an affidavit of the administrator, what do you mean? What affidavit?
The affidavit of the person in support of the petition. The one, yes. There's an affidavit in support of the petition. Then there's affidavit by the surety. Then there's affidavit of means that in the event of anything that, of course, yes, they come in. There's consent also by people who have equal status as administrator as you. They're consenting to you being an administrator. You also you must put the chief's letter. You also must put the death certificate of the deceased. Yes.
Okay. Supposing I am one of the beneficiaries to an estate and I'm not happy about the person who has been issued a grant or has been appointed an administrator, what is my recourse?
If you're not happy, you're not okay with
the person who has been appointed as administrator.
Yeah, so that will be now an application to be made.
What kind of application? What do I file?
You will file a notice of motion application where you will now, because you're not at where now you're protesting, either you can protest at the very end where now...
What is that application called?
Which one, sorry?
The one you'll be filing at that point. If you are... if you are not happy about the administrator. I'm laughing because I almost told you the answer.
The application of the one that you're not happy with the
administrator. Maybe you want an administrator removed. Or maybe even added.
Even added.
Another administrator added, or even one removed.
Maybe an application for substitution of the administrator.
Okay. I think you may need to confirm that. I wish you well. Thank you.
Thank you.
Thank you very much, Honorable Chair, and welcome again, Wakili.
Thank you. Thank you, Commissioner.
Could you explain to us the legal framework that exists to fight corruption in this country, and tell us how you will contribute to the war against corruption?
The statutes. We have the Ethics and Anti-Corruption Act. We have the Conflict of Interest Act. We have Chapter 6 in the Constitution of Kenya.
So how will you contribute to the fight against corruption as a judge?
Thank you, Commissioner. As a judge, first of all, my first job is compliance, to ensure compliance with those acts. After having ensured compliance, I should also be very open in terms of my communication, transparent. If you communicate your judgment well, you give reasons, finding, of course, then that perception of corruption weighs off, because people can see, people can follow through, and see that this is actually a well-reasoned judgment by the end of it.
Okay. Yeah. Thank you. I wish you all the best.
Thank you.
Thank you, Honorable CJ. I will ask you questions on the information that has been provided in your profile. I noticed that when you're making the application, you indicated that your ethnicity is Swahili, and today you've told us you're Nubian.
Oh yes, I had a problem. I even made a call because the Nubi was not part of the drop down. The drop down. There was no. I couldn't pick Nubi.
Okay.
So I picked my maternal side.
All
but
right.
Yes, so I didn't have. Yes.
That's fine. You were a law clerk. Which period was this?
The period of my law clerkship. Since 2017 to
2017 too?
I left in 2021 January.
Why did you leave?
My contract came to an end.
And you did not seek renewal?
No.
Why?
I wanted to pursue also.
You wanted to pursue other interests?
Yes.
Okay. You've been at the Data Protection Office for almost 2 years now?
Yeah, 2 years.
So why do you want to leave?
Of course, I've always considered judiciary a very good employer, and it's a home, a place to be. And also I want to contribute to jurisprudence. And I feel my ground, this is where now I got my grounding. And
okay. At the Office of Data Commissioner, who do you report to?
I report to the now Senior Data Commissioner.
Based in Mombasa or HQ?
Yeah, HQ.
Okay.
Yes.
Just out of curiosity, part of the referees you give, or people to give recommendations, you left out a key person, somebody I would term very key, the person you are working under, CJ Emeritus Maraga. You also left out your immediate supervisor currently, and I thought this really would help beef up your profile. Why is that?
No, my immediate supervisor is there, Mr. John Olubengo. He's my immediate supervisor. He's the one even who signed for me.
You said Mr. who?
Walubengo.
Okay.
Yes. He's my immediate supervisor. He just took over from Rose Mosero, who was there before, but she got greener pastures and left. So I included both of them, because I used to report to Rose, Madam Rose. Then when she left, now I report to.
Okay, I don't seem to have that as part of the referees, because from the three professional you gave Honorable Justice Lenaola, you give Justice Mwanaisha, Lady Justice, and Rose Mosero. Miss Rose Mosero. So anyway, it was just a concern.
Because there was part of professional referees, and then now there's part of, because that part was full, I included him on the second part.
Okay, on the second part, it's still not reflecting, but in
It's
future
nice.
when you're making an application, it's also good to take into consideration, because these are people you've worked directly
Yes,
under,
yes.
so their word would really mean a lot.
Yeah, sorry for that.
Okay.
I thought I included
All right,
him.
thank you, and I wish you well.
Because he was even aware of this.
Good afternoon again.
Good afternoon, Vice Chair.
Fine. Now, during your long number of years you've worked, during your work experience, what has been your biggest professional challenge? And how have you managed to overcome it?
My biggest challenge was when I was put now the head of the coast region. Of course, with the resource constraint and the office being still very new, we didn't have, we still don't have even a bit like a vehicle to take us through. So, and I still had to deliver. I still had my PC to fill. So I had to go to do outreach, to go to far-reach counties, to even Lamu, and ensure, of course, to the grassroots, to ensure the vulnerable people of the society also get to know about this awareness on data protection. So yes, I had to make do with what I have and still go either way. So but I managed to overcome the challenge, and as I am right now where I sit, I'm happy to report that yes, at least awareness is, even the number of people visiting the Mombasa office right now, it's very different from how it was when I started the office.
Would you describe yourself as a risk taker? If so, you may discuss some of the risks you have had to
Yes,
face as a leader.
Yes, yes, Commissioner, Vice Chair. I believe so. You'll note that even now with my current position, there's a lot of risk involved. I had to leave employment when I didn't have any other. Of course, that's a risk to go start from scratch with law firms and practice. That's a risk. And I believe throughout my life, even from the time I started my career in law practice, I was, from the very word go, Mr. Aboge took me directly to the Mombasa office to start the office from scratch and to be in charge of the office, Mombasa and the environs. All those speaks to my being a risk taker.
Okay, thank you. Santi-san.
Thank you very much, Ms. Ramadhan, and also commissioners for that very interactive engagement with you this afternoon. We always give a candidate also an opportunity to engage us before we release them. So this is your opportunity.
Thank you, Honorable CJ. But I don't know, maybe I've just remembered something from Commissioner Omwanze's question, and I was thinking, can trial within a trial be the answer to that question, where to cure the injustice? So that at least you hear that part and then we proceed. But anyway, yes, that just popped
Trial occurs in a criminal trial.
Yes, but now I was thinking, I was just thinking aloud in terms of civil. But yes, thank you. It just came to my mind.
That's homework for you.
Yes, that's my homework. Yes, thank you, Honorable CJ. I'm happy to be here today. I'm delighted to have been given this opportunity to come have this conversation with you. It's not every day that you get to have this conversation with the great mind in the same room. I don't take it for granted. I am very grateful, and I'll be happy to come back and work with the judiciary. Thank you.
Thank you. And on behalf of the commissioners, we wish you well. We wish you success. We'll get in touch with you when we complete the process. It's very competitive, but we always encourage our candidates to keep up their hope, their handwork, and their positive spirit in the service, wherever you are serving.
Thank you. Thank
Yes,
you.
you are released, except our constitution. We need it for the next candidate. Yes.
Just
Yeah.
a quick one. We talked about work. Can this zakat, which is subject to the work, be for the benefit of a Christian, a non-Muslim?
Sorry, if our
Can it be used for a non-Muslim?
the Waqf.
Uh-huh.
Yes, for as long as you fall within the destitute member, those ones who require to benefit, require the societal benefit for
It
you
can.
to. Yes, it can.
Okay.
It can.
Thank you. Have
And
the
it's-
best. Have a nice
And it has been used actually.
afternoon.
I know. Okay.